Hello and welcome back to our YouTube channel. Well, it is 14th lecture of Indian polity today and it is 23rd June 2025. Before we will start our discussion, I would like to give the brief introduction about the initiative so that if you are new to our channel, you will get more connected with us. You know, basically from the 2nd June, every day we are uploading two videos on our YouTube channel, except on Sundays. So what are these two videos about? In the first video, we discuss the daily news analysis. We do the daily news analysis. We take up the most important articles from the newspapers. We discuss them, we break them down into the simplest language possible, and we derive the possible prelims and mains questions which can be relevant, which can be formed from those articles, which can be relevant for your preparation. So what we do in our first video, we discuss the daily news analysis, or we can say we discuss the current affairs. In the second video, which is this video, here we discuss your static syllabus. So what is the motive of this initiative? The motive of this initiative is to discuss every day two important parts of your preparation. One, the current affairs, and the second, your static part. And in the static part, we had promised you one thing, that by the month of Jan 2026, we are going to complete your full syllabus. And in this, we will cover everything what is important for you to clear the exam. Whether it would be related to prelims or it would be related to mains. We will cover everything except your optionals. Everything will be covered here. And in this, we had started with Indian polity, as you can see. And this is the 14th lecture of Indian polity. And one more thing I would like to mention here, that as we are delivering these lectures, at the same time we are making the notes for you guys. We can say we are making the research paper for you guys. By reading that research paper or by reading those notes, it would cover your both prelims and mains, and I can guarantee you about that. We will cover everything what is required for you to clear the exam. Once you will read our notes, you will, and if you would have read other books, you would find the difference, but it is up to you. If you want to be the part of that, if you want our notes to lead you, that is up to you. There is no compulsion. If you want those notes, you would just have to pay 200 rupees per subject, and those notes would be available after we complete the syllabus of one subject here, like we are discussing Indian polity. After we will complete the Indian polity, those notes would be available for Indian polity, and for that you would have to mail us and we will send it to you guys. So this is about the initiative. If you are interested in it, please do subscribe the channel, do share it with your friends and hit the notification button, and let us be the part of your success. Now with this, let us start our discussion where we left in our previous class. From today we are going to discuss the fundamental duties. As I told you, we started from the 2nd June, and from the 2nd June we started discussing various concepts related to the Constitution of India. First we defined what Constitution is, then we discussed what are its important what are its salient features, not the basic features. We discussed its salient features. Then we discussed part 1 of the Indian Constitution. We discussed before that the preamble. We discussed part 1. We discussed part 2. We discussed the fundamental rights in part 3, and we discussed in our previous class part 4 of the Indian Constitution, which is the directive principles. We established a few facts about directive principles, that they are not enforceable. They are not enforceable. And about directive principles, we understood that it is the positive obligation of a state towards its citizens. Directive principles, they are the positive obligation of the state towards its citizens, that a state shall do those things for their citizens. And we discussed them in a very detailed manner. We discussed those which could be relevant for your mains. For example, the uniform civil code, we discussed them, and all the aspects which are required for you to clear this exam, we discussed everything. And we discussed that the directive principles are in the part 4 of the Indian Constitution. And after that, there is one thing called part 4a, in the Indian Constitution. And whenever you will see these alphabets with respect to any part or any article, you should assume that it was not originally the part of the constitution. It was added later. So is the case with the fundamental duties. This part 4a, it deals with what? It deals with the fundamental duties of the citizens towards the state. This is it is focusing on the citizens. It is not focusing on the aliens. It is only focusing on the citizens. These are your duties which you should adhere to, which you should follow towards the state. What state will provide, what are these duties state has provided you, and you should try to abide by these duties. So this is under part 4a of the Indian Constitution, and we established here that it was not originally the part of Indian Constitution. But when was it added? This is something important points. Basically this fundamental duties, rarely there would be a question with respect to the fundamental duties in your mains exam. This topic, it revolves around the what? It revolves around your prelims preparation. So for that, we need to have the better understanding of the facts under this fundamental duties. So first we established that it was not earlier part of the constitution but was added later, and it was introduced in part 4a of the constitution. And part 4a, and what was the amendment? It was the 42nd Constitutional Amendment Act, which was passed in 1976, and it was a time when there was emergency. So we can now understand, before emergency, there were only rights given to us. We had the fundamental rights, we had the directive principles. The state, the time it was Miss Indira Gandhi's time, she thought that, our constitution, it gives them just rights, and they are enjoying the rights. They are often going to the courts that, sir, government is not doing this, they are not giving us these rights, they are not bringing in these laws, the government is trying to interfere with our privacy, they are trying to curb our freedom of speech and expression. Then the Indira Gandhi thought, why not give them some duties? There should be some duties given to them so that they will understand the value of the Indian Constitution as well as the value of the Indian culture. With respect to this, I remembered a point here that when Constitution was framed, there was a person called P.V. Kane. He criticized the Indian Constitution. He said that if we look at the Indian Constitution, it has established the Western way of understanding. Like in the Western countries, they only give the rights. This is one of the difference between the Indian Constitution and the Western Constitution. Please remember, these facts are important. In most of the Western countries, for example, if we have USA, we have Australia, they don't give these fundamental duties. They only define the rights. They are in their constitution. There is only fundamental rights, no something called fundamental duties. This Mr. P.V. Kane, he said that, look at our culture. If we look at our culture and if we will see our upbringing, our society, there has always been a balance between the freedom, there has always been a balance between right and the duty. We have duty towards our nation, we have duty towards our elders, we have duty towards our teachers. We had grown up in this, and this constitution which India has adopted, it is in a way violative of this principle. It is more tending towards the Western understanding of the constitution, Western understanding of the society. So he in a way criticized the Indian Constitution in this regard, that we don't have the fundamental duties. Then coming back to the point, in 1976, it was the 42nd Constitutional Amendment Act when the fundamental duties were brought in, and it was the Sovereign Singh Committee which was created for that, and they gave the recommendations for that. Sardar Sovereign Singh Committee, they gave the recommendations for the fundamental duties. Now a question can be asked with respect to it, that all the recommendations of the Sardar Sovereign Singh Committee were accepted. No, not all the recommendations were accepted. Only 10 were accepted initially. Only 10 were accepted, and later by the 86th Constitutional Amendment Act, 11th was inserted, and this is with respect to right to education. It was a time when education became the fundamental right. So it was inserted in the fundamental duties, that if you have the right to education for a children between 6 to 14 years, then it should be the fundamental duty of the wards too, of the parents, of the guardians, that they should give this it should be the duty on the state too, that they should give this opportunity to their children to go to the school. So this is the basic introduction which is important for you to understand why there was the need of the fundamental duties. Initially it was not part of the Indian constitution, how it was introduced, and where from we borrowed it. We basically borrowed it from USSR. Now a question can come in the exam that which of the following constitutions in the world have fundamental duties, and the options might be, first option would be India, of course, then the second would be USA, third would be Australia, and the fourth would be Japan. And the options would be like one only, one and two only, one and three only, and one and four only. What would be the correct answer to this? The correct answer to it would be one and four, because it is India's constitution and Japan's constitution which has the fundamental duties in it, which has the fundamental duties enshrined in it. And also, now a question you can ask, sir, what about USSR? We know what happened to USSR, so that is not even a question. Now let's have a look at some important texts under the fundamental duties. Then we will go to the criticism of the fundamental duties, and then we will wind it up, because it is not something in which we need to understand and discuss and put pressure on every article, then discuss that, then criticize that. There is nothing like that. It is relevant with your prelims preparation, and the wordings is itself understandable to everyone. What we can understand, where does it stand with respect to the judiciary? Is it enforceable? No, it is not enforceable. Like directive principles, similarly, it is not enforceable. Now, when we will read these articles one by one, there I would raise a point, and you will understand it much better. Now let's move to the another slide. Let's see what is given there. Same. The fundamental duties in Indian constitution are set of moral and civic obligations that citizens are expected to uphold, that we understood. They are enshrined in Part 4A of the Indian Constitution under Article 51A, that we understood. These duties were not part of the original Constitution but were added by the 42nd Amendment Act in 1976 based on the recommendation of the Sovereign Singh Committee, that we also understood. Later on, one more duty was added by the 86th Constitutional Amendment Act in 2002, that we also understood. Currently, there are 11 fundamental duties in the Indian Constitution. They serve as a reminder to citizens that while they enjoy the fundamental duties, they also have responsibilities towards the nation and the society. Now let's have a look at these duties one by one. Here is the list of the 11 fundamental duties as per Article 51A. So what is the first? To abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. So this is the first one. Then the second, to cherish and follow the noble ideas which inspired our national struggle for the freedom, to uphold and protect the sovereignty, unity and integrity of the India, to defend the country and render national service when called upon, to promote harmony and the spirit of common brotherhood, to value and preserve the rich heritage of our composite culture, to protect and improve the natural environment including forests, lakes, rivers, wildlife, and to have compassion for living creatures, to develop the scientific tempers, humanism, and the spirit of inquiry and reform, to safeguard public property and to abjure violence, to strive towards excellence in all spheres of individual and collective activity so that the nation constantly rises to higher levels of endeavor and achievement, to provide opportunities for education to his children or ward between the age of 6 and 14 years. This was added by 86th Amendment. We understood that. Now, what is the criticism to fundamental duties? One of the major criticism to it is that the fundamental duties which should have been the fundamental duties, they are not inserted in it. For example, there is no fundamental duty. We just read it. There is nothing mentioned about the paying of the taxes on the time. It should have been the fundamental duty. If a person is not paying the tax, then definitely he is putting huge burden on the state. It leads to the fiscal deficit, and when the fiscal deficit is so huge that it can even impact the sovereignty of the country, because we have to go for the borrowings from the outer nations, from the other states, and they may in a way, for example, if we will borrow from IMF, they will in a way tell us how to frame our policies. So it should have been there that the taxes should be paid on time, or you know, there is no fundamental duty that it is the duty of every person to vote during elections. No, nothing like that so the argument is that even though fundamental duties are given, but they are very much vague in nature. They are very much vague in nature, and they are something on which there are huge there are huge understanding difference in understanding. Let's have a look again. Let us see. The first, to abide by the constitution and respect its ideals and institutions, the national flag and the national anthem. Then the second, to cherish and follow the noble ideals which inspired our national struggle for freedom. This is something vague in nature. What is something which inspired our national struggle for freedom for you is something different for me. If you will ask the congressman what was the thing which gave us this freedom, they would say it was because of Nehru, it was because of Mahatma Gandhi. If we will ask the RSS what was your contribution, how we got independence, they will have different understanding. If we will ask if you will ask Kangana Ranaut about the freedom struggle, she will say that we got independence, real independence in 2014. So there is different understanding. So the criticism is that even though we have this fundamental duties, even though we have them, but they are very much vague in nature. There is no proper understanding about it. Then similarly, the first one, to respect its ideals and institutions, the national flag and national anthem. What is this? To respect its ideals, it has given the scope of the mob justice. For example, we can take the example of the for in cinema halls, if you want to watch the movies, if you want to watch a movie there, then it was made mandatory that you would have to stand there. You will have to stand in the respect of the national anthem. There are high chances that this is something called that it is called a forced democracy, or we can say it is something called a forced patriotism, that it should be something in your heart. If you would listen to the national anthem, it should automatically come to your heart. It should not be forced that you should stand up, you should sit down. So with respect that there is a discussion, there is a criticism to it, that in our constitution, in the fundamental rights, these ideas are very much vague in nature. Similarly, with other respects also, if we will see other to defend the country and render national service when called upon, for example, to protect and improve natural environment, including forests, lakes, rivers, wildlife, and to have compassion for living creatures. What is this compassion for living creatures? Plants are the living creatures. Should we not even eat the plants now? People like to eat chicken and mutton. They are the living creatures. Should we not eat them? So what is the criticism to it? That even those ideas which are given to us as the fundamental duties, they are least important. But what should have been given, like everybody should pay taxes on time, those should have been the fundamental duties. That you should vote when there is election, it should have been the fundamental duty. The family planning, it should have been the fundamental duty, rather than these things which are given there. It is an argument. Let's have it here. Let's understand this argument, whatever your sentiments are towards it, but this is the real argument which the people are raising here. Similarly, we are talking about the scientific temper is here, to develop the scientific temper, humanism, and the spirit of inquiry and reform. What is this scientific temper? People are religious in our country. We understood that religion is something which there is nothing logical in the religion, For someone it may be superstitious, and for someone it is the faith. And you do some religious acts, you do something which is which may be superstition to you. At the same time, how, by saying that, by bringing the scientific temper, how we can bring the scientific temper? Religion and science, they don't go in line. They are opposite to each other. Majorly they are opposed to each other. How we can have the scientific temper at the same time when you are given the fundamental rights to have the religious freedom? So definitely there is a wide scope of the argument here. So this is the argument, this is the criticism to the, to the fundamental duties, and these are the fundamental duties which you need to have the understanding of. What are these fundamental duties? These few important points which I would again reiterate here, again write it here. First, it was not originally part of the constitution, not part of the constitution. Second, it was introduced by the 42nd Constitutional Amendment Act 1976 during emergency. Third, it was a sovereign committee which recommended it. Fourth thing, it is not enforceable. If the fundamental duty is violated, you cannot, if anybody violates the fundamental duty, you cannot go to the court. But here you can ask a question, important question. Here it says to cherish and follow the, here first, to abide by the constitution and respect its ideals and institutions, the national flag, the national anthem. Suppose tomorrow what you will do, God forbid if any of you will burn the flag. So can you be dragged to the court because you violated the fundamental right? No. For that you cannot be dragged to the court. But the constitution has given the parliament to make laws, and with respect to this we had the law Prevention of Insults to National Honor Act 1971. Prevention of Insults to National Honor Act of 1971. So if you will do such act, or you will burn the copy of the constitution, or you will do something crazy like that, you can be caught under this. But it should not be deemed that you are punishable, you are in the jail because you violated the fundamental rights, not for that fundamental duties, but for violating this act of the parliament. So this is how it happens. It is not enforceable. It was not originally part of it, and we had borrowed it from USSR. Right now, what are the constitutions which have the fundamental duties? It is India's constitution, ours, and Japan's constitution which have the fundamental duty. In the rest of the world, there is no scope of the fundamental duties. And also, if I am forgetting anything which we discussed, that you would already know. So this is the fundamental duty. Now again read them one by one. To abide by the constitution and respect its ideals and institutions, the national flag and the national anthem. Now you can ask a question, sir, what kind of questions can be asked from this topic, as it is particular to prelims basis. So for that you need to remember, you need to memorize by heart all these fundamental duties. A question is often asked in the exam that which of the following are not the fundamental duties. So you have to find out that. So for that you need to remember that. Remember in what way you want to remember, but please remember all these fundamental duties. And do remember that what was the 86th Amendment Act, Constitutional Amendment Act in 2002, which was added, which fundamental duty was added, what was it states when the constitution came in, whether it was there or not. So please do remember all these facts. These are very much important. Now let's again read it for you guys. I will again read it for you. To abide by the constitution and respect the ideals and institutions, national flag and national anthem. To cherish and follow the noble ideals which inspired our national struggle for freedom. To uphold and protect the sovereignty, unity and integrity of India. To defend the country and render national services when called upon to do so. To promote harmony and spirit of common brotherhood amongst all the people of India, transcending religious, linguistic and regional or sectional diversities. To renounce practices derogatory to the dignity of woman. To value and preserve the rich heritage of our composite culture. To protect and improve the natural environment, including forests, lakes, rivers and wildlife, and to have compassion for living creatures. To develop the scientific temper, humanism and the spirit of inquiry and reform. To safeguard public property and to abjure violence. To strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises to higher levels of endure and achievement. To provide opportunities for education to his child or ward between the age of 6 and 14 years. This was added by the 86th Constitutional Amendment Act. So with this, I hope that the fundamental duties are very much clear. What was important in it, we had added it. No further discussion. It is not enforceable. Please remember that. Mandamus does not apply on it. If any institution is violating the fundamental duty, you cannot go to court, sir. Please issue the writ of mandamus so that they will do this work. It is not enforceable. But why are people caught under the violation of the constitution or disrespecting constitution? Because the parliament has the right to make various acts. Why are people caught? If you why you end up in jail if you kill a tiger? Because we have the wildlife protection act. For that you are in jail, you are punished because you are violating the act of the parliament, not the fundamental duty. So with this, I hope it is very much clear. Now let's move to the another topic, which is the basic structure doctrine. Let's discuss that. It is very beautiful doctrine, 1973. It is a trademark year for India, we can say, because it was the year in which the constitution, the democracy was saved in our country because of this doctrine, which is basic structure doctrine. And one interesting about this basic structure doctrine, actually it is all discussed in Keshwananda Bharti case. Keshwananda Bharti case. There is an interesting fact about it. This case, this person lost the case but saved the democracy. Lost the case but saved the democracy. So let's try to understand that what is this basic structure of the constitution. Let's try to find out it. Let's try to understand it. To understand it, first we have to understand the basic statements given by the constitutional experts. For example, Pandit Jawaharlal Nehru. What did he said about the constitution? He said an important statement. What was that? He said that if there is any popular demand in the country, and it should be this popular, if there is any popular demand in the country, popular demand in the country, it should be capable of amendment. One of the silent feature of our constitution is that it is the living constitution and one of the largest constitution. Why? Because it is continuously going through the amendments. It is continuously going through the amendments. Please understand one thing, as I had mentioned it earlier again. I'm talking about silent features, not the basic structure. Please differentiate these two things. Silent features, it talks about what are the key components of the constitution, like how it is the largest constitution, one of the largest constitution, how it is not rigid, at the same time how it is flexible, what are the different things given in the constitution. That is different. Basic feature, that is we are here to discuss. So what did the Nehru said? Nehru said that if there is any popular demand, it should be capable of amendment. Our constitution, it is not a rigid constitution. It is going through the amendments, and there are various procedures for the amendment. Various majorities are required. For example, if you want to make an ordinary amendment, then if you want to bring in ordinary law, you need a simple majority. If you want to amend the constitution, you need special majority part 2. We had discussed all those majorities in our second class, if I will be more precise in it. So what does the Nehru say? He says that the constitution, it cannot remain static. Nehru says that this constitution which you have, it cannot remain static, because when did we frame this constitution for ourselves? It was 1949, let's say 1949, 1950, 1948. At that time the situation was different. The understanding of the world was different. The needs of the people were different. The education level they had, it was different. So the understanding, taking all those things into the consideration, what was the need of that time, what was the popular demand of that time, the constitution was framed. But after 10 years, the popular demand may change. Popular demand may change. After 20 years, it may change further. So it can't remain, the constitution can't remain static. It can't, if it is static, it would be like a religious book. So definitely this constitution, it has to It has to be so liberal that it should contain everybody in it, so that so that it can evolve by time. So this is the salient feature of it, and this is one of the basic feature of it. So this constitution, it should evolve by time. It should, there is a scope for it. There is definitely the scope for it that it should evolve. It can't remain static. It is very much dynamic. Similarly, and he said if there is any popular opinion, it should it should be capable of, amendment. Now here is a question. you know when constitution was established, at that time, about secularism, secular India being a secular country or a democratic country, it was a popular demand. It was a popular demand at that time. So there was it was introduced. Maybe after some years, maybe right now in 2025, the popular demand has changed with respect to these two things. Maybe right now the people in our country, the majority in our country, they want it should be the Hindu Rashtra. It should be a Hindu state. India should be a Hindu state, and also it should be a dictator state. There should be no democracy. It should be a dictator country. So can the constitution be amended in this way? The question, it is a very serious question. Even as the Nehru says, any popular demand should be capable of amendment. Suppose this is the popular demand that it should be the Hindu state and it should be capable of, we don't want a democracy here, we want dictatorship here, we want Narendra Modi ji forever here. It is the popular, maybe it would be the popular demand. Can we do it? Can we make it like that? No. Why? Initially it was not mentioned in the constitution, but because of this Keshwananda Bharati judgment, this thing came that there is something called basic structure. That is what we are discussing. Similarly, we will come to this point again, but here please understand that. Similarly, we have another person, namely Dr. Ambedkar. Everybody would have heard about that person. Very great person with great personality, gave us the constitution. And he said, when we framed this constitution, we could not satisfy everybody in our country. We cannot satisfy everybody in our country. Even if we are making any statements, we cannot satisfy how much logical you can be, how much logical you are, but you cannot satisfy everybody. So what he said, if you disagree with the disagree with the constitution, then what you have to do, come in the legislative assembly, come in the parliament, have the 2/3 majority, and change it. So in simpler terms, what Dr. Ambedkar is saying, that this constitution, it is static. If you want to change it, wherever you want to change it, whatever you want to change it, just change it. But the only condition for that is you should have this special majority of 2/3. So what did we get from this? What did we understood from these two statements given by these two experts of the constitution? It says that anything in the constitution can be amended. It says anything in the constitution can be amended. So with respect to this, came the year 1951, an important case. It was the First Amendment Act. First Constitutional Amendment Act was introduced, and in it, Article 15(4) was added. What was the reason for that? We had already discussed it. There is no need to waste our time again revolving around the same bush. And also, in this Article 31A and Article 31B were added, ninth schedule. They were added. So, to amend this, what Parliament did, they used to amend this constitution. What they did, they used Article 368 of the Indian Constitution. Now, the matter went to the court. Shankari Prasad Deo versus Union of India, 1951. The case Shankari Prasad Deo versus Union of India, 1951. What he said, sir, this is against the constitution. Why this amendment is unconstitutional? Why? Because it is violating article 13(2). Under article 13(2), you cannot bring in any law. By any law you cannot abridge, you cannot amend the fundamental duties. So here they are violating article 13(2). So to it the judiciary said, we are sorry, we have, the parliament has the power to amend the constitution, to amend the they have the power to amend it. And also they said that this law under article 13(2) does not contain the constitutional amendment act. This law which is mentioned in article 13(2), it does not contain constitutional amendment act, so they have the right to amend it, and they had done great. Another thing which was also mentioned in it, sir, this is not the elected this amendment, it was brought up by whom? These people, they are not elected by the people. There had no election has happened to bring in such people to amend it. There was a national assembly which was formed for the forming of the constitution, and from there it was made who will be the prime minister, who will be the president. There has been no election yet, so how they can amend it? But the court said it is valid, through a constitutional amendment you can add it. Then this was the stance of the court in 1951. What was the stance of the court? 1951, you can amend, parliament can amend anything. Now came the question, another question came, similar question, but this time the year was different, the case was different. And what was the year? It was 1967, and the case was Golaknath case. And this case was heard by 11 judge bench, and the same question was raised, but the answer was different. In 1967, Golaknath case heard by 11 benches. Question: does Constitutional Amendment Act come under Article 13? Does it violate the law which is mentioned under Article 13(2)? Does it contain Constitutional Amendment Act 2? But here the stance got changed. It said that yes, it does contain, and you can't amend the constitution. You cannot amend the fundamental rights, because it is very much restricted in Article 13(2). And also the point which was raised here, that what was the point raised here, that the Article 368 does not give power to the parliament. It does not give power to the parliament to amend the constitution. People were confused. Sir, how it does not give the power to the parliament to amend the constitution? The court said, look at Article 368, look at the title. It gives procedure who will amend how it should be amended. It does not say who will amend the constitution. It just gives the procedure to amend the constitution. Then they said, who should amend the constitution? And the court said, I don't know who should amend the constitution. Maybe make a constitutional assembly, they will amend it. We saw that how constitution came in. These constitutional assembly elect the constitutional assembly, and they give this duty to them. They will amend it. What about the parliament? They can only bring in the ordinary law making power. They have the only ordinary law making power. So this Golaknath judgment, what it did, it divided the powers of the parliament, the ordinary law making and the constitutional powers. What this judgment said, Golaknath judgment, it said that this ordinary law making power, it is with the parliament. This constitutional power, it is not with the parliament. So it is not with the parliament. When it is not with the parliament, then they cannot amend it. They need to there is a need that they have to appoint a new body. There is a need of the appointment of a new body which will amend it. But this time it was Miss Indira Gandhi, and her personality was different. She would not accept the defeat. What she did, she amended the constitution. She said, okay, it is your choice. You are saying that we cannot amend the constitution. Let me amend the constitution and show you how I can amend it. She amended the constitution, and what she did, she brought the 24th Constitutional Amendment Act, in which if any constitutional amendment bill is passed, the president shall give the accent to this bill. He cannot reject it. He cannot withhold it. He has to give the assent to the bill. First, 24th Constitutional Amendment Act. Then she further added in this amendment that this Article 13 will not apply to Article 368. This Article 13, by an ordinary law you cannot amend the fundamental right. It will not apply to Article 368. Then the question was asked, ma'am, the Supreme Court, the judgment, the point which they raised that the Article 30 is 368, it itself does not give the power to amend the Constitution. The title of Article 368 is different. We are not sorting the issue here. She said, no problem. Let's change the title of Article 368. Article 360, the title was changed. Earlier it was the procedure to amend the Constitution. Now the title was, it is the power of the Parliament to amend the Constitution. It was okay with her. Then she introduced the 25th Constitutional Amendment Act, passed Article 331C. It was added, and also PV Purs was abolished. Kerala, there were land reforms in Kerala. Land Reforms Act passed, and it was added in the 9th schedule, and by the 26th Constitutional Amendment Act. Because of this Kerala land reforms, there was a person whose name is Keshwananda Bharti. Keshwananda Bharti. He was running a mutt, and his property was sealed. So he said that if I am not giving this property, how I can profess my religion under Article 25? So he went to the court, and the lawyer who would represent him was Mr. Nani Palkiwala. Lawyer was Mr. Nani Palkiwala. Mr. Nani Palkiwala represented Keshwananda Bharti. It was Keshwananda Bharti versus the state of Kerala case. The law which was introduced in the 9th schedule. Under this Land Reform Act, they can confiscate, they can take any land, any property, whatever they want to, and even from the religious organizations. So this question went to the court, and it was heard under the Keshwananda Bharti case. Now, court saw that there are various cases coming like that. If we will see the principal module of those cases, it is all about one thing: whether Parliament can amend anything, whether Parliament can amend whatever they want to amend, whether it is the power of the Parliament to amend anything, whatever they want. The primary question was under the Keshwananda Bharti case. The primary question was whether Parliament can amend the fundamental rights, whether Parliament can do whatever they want to do. The primary question was that under this Keshwananda Bharti case. Now let's discuss this one by one. What were the arguments raised by the Nani Palkiwala, and what was the judgment? This is the beautiful judgment, and it is the landmark judgment. Even though the Keshwananda Bharti, he lost his case, he lost his property, but still this judgment is beautiful because it is a landmark judgment. It is said that it saved the Indian democracy. 13-judge bench sat on this case. What were the arguments made by the Nani Palkiwala? He said that he talks that there is something called implied restriction. But he said there is something called implied restriction. What is this implied restriction? And he raised the question. He said that in the Constitution, if you will read it, there is nothing called that there is nothing called the restrictions with respect to amendment. You can do, parliament can do whatever they want to. But he said that can the parliament pass the law in which it says that from today we have a dictatorship in our country? Can parliament make such law? Or can it say that from today this constitution ceased to exist? Ceased to exist. Everything in it is null and void. Can it make a law and say that from today we are going back to the British India? We are going to be again British India. Can it say that from today there is no election? Can can they make such laws? And this question they were beautifully asked. And also, is the power of the parliament, is the power of the parliament to amend the constitution supreme? Is it immune of the judicial review? These questions were asked. And what was the real question? The real question under the Keshwan and the Bharati judgment, which was discussed, is the power of the parliament supreme in amending the constitution. So these questions were asked, and the Supreme Court, they understood it, and by the 7:6 judgment, 7:6 judgment, they said that, what they said, that there is no implied, with respect to implied restrictions, they said that there is no implied restrictions. But they also said that, he lost this case, but they also said that there is something called basic structure. There is something called basic structure, and this basic structure you cannot amend it. In simpler terms, there is something called basic structure, and you can never amend this basic structure, whatever you want to do. And what is this basic structure? It is decided by, it is not codified. This basic structure, it would be defined by the Supreme Court, by the courts, on case to case basis. This basic structure, it would be defined by the Supreme Court on case to case basis. So in this way, the basic structure doctrine was established, and in this way we have the judicial review basic structure, democracy basic structure, sovereignty basic structure, secular nature of the country basic structure, independence of the judges is the basic structure, and so on. And it is decided by whom? It is decided by the judiciary. There is no codification of the basic structure. Now let's move to the another topic, which is whether this basic structure, is it good or is it bad? What are the arguments? There can be a question on the basic structure, by saying that by this basic structure, it in a way gives the extra power to the judiciary to overreach in the executive matters. A question like it can be asked in the exam. We will see what this overreach when we will discuss judiciary. But the point is, this basic structure, it is something which is open to judiciary only, and they decide it on the case to case basis. So doesn't it give the judiciary that extra power that they can restrict anything under Article 142? They can do anything, and they will cite that it is the basic structure, don't amend it. So they are restricting the powers of the parliament. Now let's see what are the arguments against basic structure. Let us discuss arguments against basic structure. And now after this we will discuss what is the process of amendment, and union executive we will discuss it from tomorrow. And today we will discuss part 4a completely. So arguments against basic structure. First thing is a judicial innovation. In a country, judiciary is so important. Sometimes it is more important than government, it is more important than the executive. But there is one thing, executive, the legislature, they don't like judiciary. It is not something written anywhere, but definitely they don't like each other, because judiciary, it always keeps them on the check. There is separation of power, there is checks and balances. Judiciary always keeps them on the check. And the way there are certain articles in our Indian constitution, it gives the extraordinary power to the judiciary. Like when we will discuss the Indian judiciary, under that we will discuss Article 142. You will see that how extraordinary powers are given to the judiciary. So what first allegation towards the basic structure? It is a judicial innovation. In constitution, in our constitution, nowhere is this term basic structure mentioned. It is something adopted by the judiciary. It came by the judicial innovation, by the judicial creativity. It is nowhere mentioned. Second, it leads to the tyranny of the unelected of the unelected office, judiciary. It is not elected by the people, judiciary, they are not elected by the people. It gives this the tyranny, it gives them the extraordinary power to the judiciary, and they can do whatever they want to do. If this power is with if this power is with the executive or with the legislature, we elect them, and if we are not happy with them, in the next election we can remove them. But with the judiciary, who are not elected, who are appointed, who get this office by the appointment, or their how they had understood it, what are the basic qualifications for that, which we will discuss in judiciary, who are appointed. If the appointed organization, if the appointed office will have such power, it is very much tyranny in nature. It leads to the extraordinary power, and it can suppress the popular demand of the people. So this is one of the allegation against it. Similarly, the case which I discussed earlier, before we discussed the basic structure, I told you, when we became independent, what was the popular opinion? Popular opinion of the people. The popular opinion of the people was that we have 80% Hindus in our country, and their opinion was that we should be secular country. So it was the popular opinion. Maybe today the popular opinion has changed, and what did the Nehru said that every popular opinion should be capable of amendment. Maybe today 80% of the people don't want it to be the secular state. Why are we not able to go through the popular opinion? Why we are not able to take their opinion? Who matters? 80% of the people say that. So this is against the popular opinion. This will work against the popular opinion. It in a way dilutes the popular opinion. And if we will look, what does the democracy mean? We would from the 5th class we are discussing democracy. The simplest definition: it is of the people, by the people, for the people. If it is of the people, it is by the people, and why it is not for the people? And democracy, it is majorly, there should be majority, it is majority, 80% of the population want there should be the Hindu state, hypothetically telling. Why there is not this? It is against the popular opinion. So this is also one of the argument against it. And similarly, it gives extraordinary powers to the judiciary. For example, to the CJI in the appointment of the judges, it was established that under the collegium system, the opinion of the CJI matters with respect to the appointment of judges. But in 2014, we saw that how it was replaced by NJAC. But in 2015, NJAC was not accepted because by the judiciary, because there were key points in it. And what was the important point highlighted by the judiciary? That the Chief Justice of India, his opinion is in judicial employment is a basic structure. So it in a way gives a free hand to the judiciary, and it leads to the arbitrariness against Article 15, Article 14. So definitely there is a concern with respect to the basic structure when we look at these arguments. Now, what are the arguments in favor of it? What we discussed so far, that is in favor of it. If it was not there, the parliament would have done anything crazy, and we could have not, and we would have been mute spectators. It would have changed into the dictatorship, and we could have not done anything. You would have heard about Miss Indira Gandhi. A movie about her also came, and Kangana Ranaut, as an actress, I like her very much, but while her psyche is, where her mental state is. I doubt that. That is something different to be, and it is not our discussion right now. So here is the point. You know, let's see what are the arguments in favor of it. There was an election, and there was a person called Raj Narayan. Raj Narayan case. Narayan case. He was contesting against whom? He was contesting against Miss Gandhi in Bareilly, and Miss Gandhi won the election. But he went to the court, Allahabad court, Allahabad High Court. What he said, he established a few points. He said that Miss Indira Gandhi, she should be disqualified. The court said, why should we disqualify the sitting prime minister? He said that, look at the picture. She is using the government in launching her campaign. She is doing the electoral malpractices. She is doing electoral malpractices. And this case was heard by the Allahabad High Court, and they gave the judgment in favor of this man, Raj Narayan. But the Miss Gandhi, being the Miss Gandhi, she approached Supreme Court, and Supreme Court stayed this judgment of the Allahabad High Court. And here one point was established by the Supreme Court, that even if you can stay in the Lok Sabha, but you can't vote. Then about Miss Indira Gandhi, she did not accepted the defeat that well. During emergency, she brought in Article 39th Constitutional Amendment Act. And what was that? If President, PM, Speaker of the Lok Sabha is in case against the electoral malpractices, if there is a case against the president, if they are under Article 39 Constitutional Amendment, what was established, if there is a case against President, Prime Minister, Speaker of the Lok Sabha, if the case is with respect to the electoral malpractices, then such case shall not be heard by the Supreme Court or the courts. It should be heard by the tribunals. This case should be heard by the tribunals, and who will establish this tribunal? It is the government who will establish this tribunal. It was Amendment 39. And another amendment she brought in, what she did during the emergency, she knew that once emergency would be lifted, she may lose election and it will affect her. So she brought 41st Constitutional Amendment Act. And what she said in this, she said that no criminal case can be filed against the governor, speaker, PM, president, even after her not being in the office, even after her retirement. In simpler terms, we can say. If these amendments would have stand, what would have been the situation in our country? We had been the dictator country since very long, and no way BJP would have come into the power. Congress would have been the only political party here, and it would have been there would have been the nepotism. Monarchy would have been here, that only the Indira Gandhi's children would have been the PMs of our country. But what court struck both the amendments, and they said that free and fair election, it is the basic structure of the constitution and it can't be violated. Similarly, rule of law, it is the basic structure of the constitution, it cannot be violated. So this is the discussion about the basic structure doctrine. Now let's move to the last part of this discussion. Then from tomorrow we'll discuss union and executive. What is the last part of this discussion? Last part is how is this constitution amended, how this Constitutional Amendment Act is completed. That we will discuss. Then after that we will shift to what? We will end our class, and from tomorrow we will discuss union and executive. So here the question is, what is the procedure for amendment? What is the procedure for amendment? First, bring a constitutional bill under Article 368. Who can introduce this bill? Is it private member or the minister from the government? Anybody who is private member, who is not a minister, who is MP but not a minister. This is private member. Any private member or the minister can introduce this bill. And what is this bill? It is a proposal. What can be in this proposal? To amend the fundamental right, to remove the fundamental right, add schedules, remove the schedules. But one thing you have to keep in the mind: you can't disturb the basic structure. You can't disturb the basic structure. So, bill under you introduce the bill under Article 368. Where can first who can introduce it? Any person. It can be introduced by the private member as well as the minister. Second question: where can it be introduced? Should we introduce it in Lok Sabha or in Rajya Sabha? It can be introduced anywhere. It can be introduced in Lok Sabha. It can be introduced in Rajya Sabha. Both. So by both, it can be introduced anywhere. Then, do we require the prior approval? Do we require the prior approval of president for this? No, we don't require the prior approval of the president for the constitutional amendment bill or amendment act. Then, is there a scope for the joint sitting? Scope for a joint sitting. This bill, once passed by the Lok Sabha by the 2/3 majority, and 50% at voting, it should be passed by the same majority in the Rajya Sabha. Now let's suppose if it is being passed in the Lok Sabha and not in the Rajya Sabha, or in the Rajya Sabha it is being passed not in the Lok Sabha. So what will normally happen? That there would be a joint sitting where all the members from the Lok Sabha and all the members from the Rajya Sabha will come in and they will pass the bill by the simple majority. Now here is the question: is this constitutional amendment bill, is there any scope of joint sitting? No, there is no scope. No scope of joint sitting. Definitely, that is very much clear. Then, once this bill is passed by both the houses, then we will send it to the president. What will president say? Do president have the power to say no? Totally no. Can he withhold? No. What power he has? He can only say yes, please. He has to pass the bill. So this is with respect to the Constitutional Amendment Act. Now let's suppose you want to amend the constitution, but you are altering with the federal feature. You are altering with the federal feature of the constitution. For example, you are altering with the election of the president. You are altering with the election of the president, because for the election of the president you need the state MPs also to vote on that. You are altering with it. For that, if the federal feature is being impacted in this constitutional bill, what you have to do? Once this process will be completed, once the parliament, both Lok Sabha and Rajya Sabha will pass the bill, then same bill with same process, it will be sent to the all the state legislative assemblies, all the state legislative assemblies, which will contain UTs also with the legislative assemblies. For example, Puducherry, J&K, and Delhi. It will be sent to them, and they have to pass it. 50% of them should pass this bill by simple majority. Once the 50% of the state legislative assemblies will pass this bill by the simple majority, then it will be sent to the president, and president has to give the assent, and then this amendment will complete. So this is how the constitution is amended. Now with this, I hope you had understood the topic. I hope it is very much clear to you guys. If there is any confusion, please do write in the comments, and please do share with us what else should we bring for you. Now with this, let's have a small little introduction about the union and executive. Let's discuss that too, and then we will complete it. So far I guess everything is very much clear to you guys. First, we will solve a question with respect to the fundamental duties, a prelims model question. Then we will move towards the union and executive. Let's solve the question first. What does the question say? Consider the following statements regarding the fundamental duties enshrined in the Constitution of India. First, the fundamental duties were added to Constitution by the 42nd Amendment Act. 100% true. They are justiciable in nature, meaning they can be enforced by the court. Incorrect. The duty to provide opportunities for education to a child between the age of 6 and 14 years was added by the 86th Amendment Act. True. The Swan Singh Committee recommended the inclusion of fundamental duties in the Constitution. That is also true. The correct answer to this question would be option 1, option 3, and option 4. And from the code given below, the correct code would be option B. With this, we had completed the fundamental duties as well as the basic structure doctrine. Now let's move to the another topic, which is in part 5 of the Indian Constitution, and it deals with the Union Executive. What it deals with? Union Executive. So what is this Union Executive? What does it contain? It contains the president. A question about it may be asked. It contains the president. It contains the vice president. It contains the prime minister. It contains the cabinet of ministers. And it also contains what? It also contains the Attorney General of India. Attorney General of India. So these are the offices which are contained in the Union and Executive. So let us start with the Office of the President. Office of the President. We were under the British rule before we got independence, under the British rule. And we had already the Government of India Act of 1935. Government of India Act of 1935. And we had the inspiration of this democracy from them only. Even though the British were the colonizers, but we had this understanding that how they treat their people in England, that is something different they treat us in India. So what did we actually wanted? We wanted that. But what was our aim? That the way they are treating their people in England, similarly we should be treated. Similarly, we should be treated. It was not the British government, as Mahatma Gandhi said, that it is not the British government in India is bad, it is full British government is bad. But the real point is, British government in England was different. Their approach towards the people were different. Their rights were different. And with respect to India, it was totally different. So the basic idea was, once we got the independence, what is the nature of our human? What is the nature of human? That they will go back to what they originally were. They will look at from where they had. For example, I will explain you one thing here. Suppose you belong to any particular religion. Suppose you are a Hindu. Your family is a Hindu family, and you were born in England or USA. Let's say USA more more Western than England itself. Let's say you were born in USA, and in USA the morals which you had got are different. You don't know about God. You don't know anything. You are not religious. You are a kind of a atheist. But suddenly after a few years, when you are 25, suppose you are 30, an idea came to you that how is this possible that there is no God? Now, what is the first thing? If you want to follow the religion, if you want to follow any religion, which is the first religion you would look into? Definitely you would look into which religion? You would look into Hinduism, because your base is Hinduism. Because even though you are not following it, but still you are connected to it. Similarly, in our constitution, when we got the independence, even though we did not like the British rule, but their democracy, the ideas of democracy, the way they govern their people in England, we liked that, and we adopted this thing from them. We adopted these things from them. And similarly, the office of the president was adopted from there. What is this office of the president? What is the similarity between the presidential office and the monarchy in England? Both of them are not the real heads. They are the he is the head of the state. He is the head of the state. He is de jure and de jure. He is de jure. But the de facto is different. Who is the de facto? De facto is here PM, also here PM. But what is the difference between the Britain president, our president, and the British monarch? This England, they have the monarchy democracy, and we have the republic democracy. Our president is being elected. We elect our president. So this is the basic understanding which we need to have. This is the basic understanding which we need to have. Now let's discuss. Let's start with what does the article say about the president. Let's try to understand that. What does the article say? What does the constitution say about president? In the constitution, we have the very small article, and in the article is Article 52. After we complete the fundamental duties, after that only there is an article called Article 52. What does this Article 52 say? Article 52 says that there shall be the President of India. What does it say? It says that there shall be the President of India. No matter what will happen, no matter if the sitting president will die, if anything will happen, no matter what the situation would be, no matter if you are fighting a war with Pakistan or China, whatever will be, there shall be the President of India. Article 52. There shall be the President of India. If we read the wordings of this article, it is categorically saying that this office cannot remain vacant. The office of the president, it cannot remain vacant. Right now we are discussing part 5 now, part 5 of the Indian Constitution. Please remember that a question may be asked, president is in which part of the Constitution, so do remember that. So this office cannot remain vacant. It should be always occupied, and it is mandatory for our country. If president will die, then the vice president will take the office, and within 6 months there would be re-election. Or if he is absent, then this situation will be different, which we will read, which we will discuss one by one. Then we have Article 53. What does this Article 53 says? Article 53 says all the executive powers are vested in president. What it says? All the executive powers are vested in president. Now the question is, what is this executive power? This is the real question. Even if the constitution says all the executive powers are vested with the president, the question is, what is this executive power? What is that? And that we will understand, we will discuss tomorrow, and we will try to complete the office of the president if possible tomorrow. So thank you for staying with us. Thank you very much, and have a nice day. Please do subscribe the channel, do share it with your friends, and do write in the comments what do you feel about this initiative. This is beautiful initiative we had started. Every day we discuss various classes, 2 classes. In the first one we discuss the important articles in the newspapers which are relevant for you. In the evening we discuss the static syllabus, and we had promised you to come that we will complete your syllabus. So it is totally free initiative. It is for you. And write in the comments what else should we bring for you. We are here to help you. Thank you for staying with us. Thank you very much, and have a nice day.